The next case on the call of the docket is agenda number 3, number 1255959, People of the State of Illinois versus Omega Moon. Mr. Costandilla? Nada, sorry.
Good morning, Your Honors. Good morning, Counsel. May it please the Court. My name is Eric Castañeda, and I'm with the Office of the State Appellate Defender on behalf of Ms. Omega Moon. May Your Honors please feel free to anglicize my name as Castaneda or Castaneda. Your Honors, Ms. Moon was convicted by a group of jurors that were not administered a trial oath to try a case. That oath requires that the jury solemnly swear to render a true verdict according to the law and the evidence of a particular case. There was no objection by either party. Ms. Moon raised the error in a post-trial motion, and at the hearing on that motion, the state conceded that it was structural error to fail to swear in the jury with the trial oath. While the trial judge admitted that she erred in not administering the jury with the trial oath, she found that it was harmless. The appellate court affirmed over a dissenting opinion, and we are now before this court asking that this court find that the failure to swear in the jury with the trial oath violates an accused's Sixth Amendment right, is structural error, and requires automatic reversal. Now, the state concedes that at the time of the founding of the Sixth Amendment, the common law jury oath required the jury to be sworn in with an oath that they would render a true verdict according to the evidence. What the state does not address, however, is that just last year, in Ramos versus Louisiana, the United States Supreme Court held that we need to look to the common law at the time of the founding to give meaning to the Sixth Amendment. And again, the state tells us that at the time of the founding, there was an oath that required juries to swear to render a true verdict according to the evidence. The United States Supreme Court in Ramos rejected a functionalist approach in interpreting rights preserved under the Sixth Amendment. And it warned that it is not the judiciary's role to reassess such rights as to whether they are still important enough to retain in contemporary society. Courts have been entrusted to protect and preserve rights that emerged at common law, and which the founding fathers found vital enough to preserve under the Sixth Amendment. The right to a sworn jury is one of those rights, as it emerged at common law and it was preserved under the Sixth Amendment. The United States Supreme Court in Lockhart versus McCreed defined that for constitutional purposes, a jury is a group of jurors that can conscientiously and properly carry out their sworn duty to apply the facts to the law of a case. The few cases relied on by the state engaged in the exact type of analysis that was denounced by the United States Supreme Court in Ramos, in that they all took a functionalist approach instead of looking to the history of that right that was preserved under the Sixth Amendment. And it's a great thing that this right emerged at common law and that it was preserved, because oaths are important, especially within the legal context. An attorney cannot practice law even though they've been to law school, taken numerous tests at the bar, until they are properly sworn in. Here in Illinois, not until they are properly sworn in by this court. It is the same with the United States President. They cannot commence their duties until they have been properly sworn in.
Counsel, does it make any difference that we don't have a codified oath?
Well, no, Your Honor, because as stated, when we look to the common law, there was an oath in place at the time that required jurors to swear that they would render a true verdict according to the evidence. And we do have the Petite Juror Handbook, which is furnished by the Administrative Office of the Illinois Courts, which the state does not address. And under that book, that oath requires that the jury render a true verdict according to the law and the evidence. This complies perfectly with the Sixth Amendment. Again, oaths are important, and they serve an important role as official demarcations signifying the commencement of something. The trial oath signifies the legal formation of a jury, of an impartial jury under the Sixth Amendment. And the trial oath serves to awaken the conscience of the jury and impress upon the jurors the serious duty imposed upon them. The jury needs to solemnly swear an oath to render a true verdict based on the evidence because they care about it and they take it seriously, as was demonstrated by the study that was conducted here by Judges St. Eve and Judge Burns, that the jurors care about the contents of the oath and they take it seriously. And again, we do have an oath here under the Petite Juror Handbook to guide the courts. There's also jeopardy implications to consider here. It is important that the jury be sworn in with the trial oath because it is at that point that jeopardy attaches. The Second Circuit Federal Court in Wedolowski and the DC Circuit Court in Green both explained that when the United States Supreme Court in Surfass held that jeopardy attaches in a jury trial when the jury is impaneled and sworn, the word sworn specifically refers to the trial oath and not the voir dire oath. And this makes sense because the word impanelment already includes the proposition that the jury has been provided with the voir dire oath.
Counsel, do you agree with the Georgia Supreme Court in Spencer that an acquitted defendant could be retried if the jury wasn't sworn?
Yes, under the Sixth Amendment, it doesn't prevent it. It doesn't prevent it. If the jury is not sworn, then, as was the case in Spencer, the state can certainly retry the accused. Without addressing Wedolowski, without addressing Green, the state proposes a bold departure from the bright line rule of when jeopardy attaches by stating that jeopardy may also attach under the voir dire oath. This flips the entire rule on its head and it injects confusion into the law. In Illinois, in addition, in Illinois, the statute against double jeopardy maintains the bright line rule of when jeopardy attaches during the different criminal proceedings. And it maintains the bright line rule that jeopardy attaches in a jury trial when the jury is impaneled and sworn. The state also fails to address the implications that in Illinois, the swearing in of the jury with the trial oath marks the point when an accused no longer has an absolute right to waive a jury and elect to proceed with a bench trial instead. So this court should reject the state's position to go down this rabbit hole and depart from the bright line rule as it injects confusion into the law of this well-established bright line rule of when jeopardy attaches. And the failure to swear in the jury with the trial oath amounts to structural error because it is a constitutional right so basic and so fundamental to a fair trial that remedying the error is necessary to preserve the integrity of the judicial process. And for all these reasons, Ms. Moon asked this court to find that the failure to swear in the jury with the trial oath violates the Sixth Amendment, amounts to structural error, and it requires automatic reversal.
Counsel, am I correct that the defense lawyer here was a public defender? He's represented a public defender, correct?
Yes, Your Honor.
And also in our record, there are two affidavits from colleagues who were in the courtroom who said that in the moment, they were aware that the wrong oath had been given, correct?
Correct.
Should we consider that at least your colleagues understood that there had been an error and yet no objection was made?
Yes, if this court does consider, it is our position that it shouldn't be considered here because that's an issue apart from denying Ms. Moon her Sixth Amendment right to a fair trial. But this court held in Cole that it is not the entire public defender's office that owes a duty to the client. Here, it was Mr. Andrew Rona who owed a duty to Ms. Moon. And there is no indication on the record that he tactically harbored this issue. The state actually conceded before the trial court that this was structural error. The court refused to find that this was a tactical harboring by Mr. Rona. And the state was equally there, and they also didn't object to this. So that rationale applies equally to the state. If they would have found an acquittal, they also had not objected to the error. Another thing is that the trial judge admitted that it was her duty to make sure that the jury was properly sworn in. And I think that points to the structural nature of the error here, is that everyone has an interest in making sure that that jury is sworn, that we have a legal determination of innocence or guilt. Another case I'd like to point to is in Sevi. This court rejected that same argument there, that a defense counsel would risk not objecting to the error in hopes that if the defendant was convicted, that error would result in a new trial. And this court found that that just doesn't make sense. And this error is 100% preventable. All the court has to do is properly swear in the jury. And only when the court doesn't do that, when the state doesn't object as well, is that type of conduct enabled, assuming that there is some sort of tactical harboring by any attorney. And the last thing I'll mention about that is that there are matters and ways to deal with this type of conduct if there is evidence of some unethical conduct by any attorney. Attorneys are presumed to be ethical lawyers, as they are officers of the court. But if there's any evidence of that, there certainly is ways to deal with this type of conduct through the ARDC in ways that it doesn't affect an accused's crucial Sixth Amendment right to have a fair trial. So if your honors are going to consider it, you should consider that that was really not an issue here. If your honors have...
Counsel, if we were to apply what you call the functionalist approach, do you disagree with the appellate court here that the jury was apprised of the essence of the oath through voir dire, admonishments, instructions, and things of that nature?
Yes, and for two reasons. The jury was never told to render a true verdict according to the evidence. They were certainly never provided the trial oath, but that is exactly what the court in Ramos denounced, is that functionalist approach, that, you know, we have other equivalents of the trial oath. That is not, the founding fathers would not have found that this jury was a legal jury under the Sixth Amendment. And that's what Ramos tells us, is we need to look to the common law. And at the common law, there was a right that the jury be sworn in with the trial oath, and that was preserved under the Sixth Amendment. So yes, I do disagree with the appellate court, your honors. And again, your honors, we ask that you find this to be structural error and that it requires automatic reversal. If there are no other questions, I'll be back here in rebuttal. Thank you, your honors.
Thank you, Mr. Castaneda. Mr. Garson Fisher.
Thank you, Your Honors. Good morning, Your Honors. Counselor, may it please the Court, Assistant Attorney General Garson Fisher for the people. Your Honors, as Justice Tice's question alluded to, defense counsel did not object at the time of the trial oath when any possible error in the oath could have been easily cured by the court. As a result, defendant's claim now of error in the trial oath is forfeited, therefore is only subject to review if it can satisfy the standard of plain error. Now, defendant doesn't argue that the evidence is closely balanced, so the claim is only subject to review if the error either undermines the fundamental fairness of defendant's trial or the integrity of the judicial process. The trial oath is one of many protections that exist under Illinois law to ensure that defendants in Illinois receive a trial before a fair and impartial jury. And this court has held that in a case like this one, where the record does not suggest that defendant did not receive a trial before a fair and impartial jury.
Mr. Fisher?
Yes, Your Honor.
Is someone actually a juror unless they're sworn?
Well, Your Honor, defendant's position is that the Sixth Amendment, when it uses the word jury, necessarily means a sworn jury. Now, the historical record at the time of enactment, which the briefs go into great detail about, some of the records from that era refer to a jury as a sworn body, others don't. So I don't think the historical record necessarily demonstrates that the Sixth Amendment meant sworn jury when it said jury. But the people certainly don't agree that there's anything in the historical record that suggests that the Sixth Amendment codified a specific content to the oath administered when a jury is sworn in. We know here that the court directed the clerk to swear the jury in, and we know from post-trial proceedings that the parties agree that the clerk then read the jury an oath appropriate to voir dire as opposed to one tailored to their role at trial. But
Tailored to their role as a juror now.
well, yes, Sharon. So the jury was sworn in, and under Illinois law, both by statute and by rule, courts are directed to swear the jury in, that the jury must be sworn. There is nothing in Illinois law that directs the judge as to the contents of the oath that should or by any standard must be given for that to have occurred. Defendant points to the Petite Juror Handbook. Now, the handbook and the page on this court's website that defendant cited to in their brief don't provide specific language that's required by the oath, but more fundamentally than that, the Juror Handbook doesn't direct or guide courts in how they conduct their business at all. It is a document that's written for laypersons who are prospective jurors to give them a general idea of what to expect when they serve on the jury. So there's certainly nothing in Illinois law that dictates what the contents of the oath need to be when a jury is sworn in. And as discussed...
But counsel, I mean, these oaths aren't even close.
Your Honor, arguably under Illinois law, simply having the jury stand up and say, do you swear to do your job as a jury, satisfies the statute and the rule. There's no question that the contents of the voir dire oath provide no guidance whatsoever to the role of a juror after voir dire. So to the extent that there is any standard as to what the contents of the oath needs to be under Illinois law, we would agree that the contents of this oath didn't meet that standard. But that doesn't mean that a reversible error occurred where it's been unpreserved as here. This court has held that so long as a defendant has counsel and has an impartial adjudicator, that any error, even if it were constitutional, is presumed to be subject to forfeiture. And there's no dispute that this claim is forfeited because it wasn't objected to. And that's true of other protections of the right to an impartial jury that implicate Sixth Amendment rights. An error in the administration of the 431B inquiry regarding the zero principles is not second-pronged plain error. An error in the administration of the voir dire oath is not second-pronged plain error. The erroneous denial of a peremptory challenge is not second-pronged plain error, because an error in the administration of any one of these protections doesn't, in and of itself, mean that defendant was denied that fundamental Sixth Amendment right to a fair and impartial jury. Now, obviously, the denial of the right to a fair and impartial jury would be a second-pronged plain error, a structural error, but because Illinois law has numerous protections that ensure that right, and defendant received the benefit of those protections here, an error, this court has repeatedly held that an error in the administration of any one of those protections is not second-pronged plain error
Mr.
by
Fisher?
itself.
With regard to becoming a juror, though, you're saying everyone who's sworn in voir dire is an oath for a juror?
Well,
I mean, so when do you become an actual juror?
so I think under the Sixth Amendment, you become a juror when a jury is impaneled. All the Sixth Amendment says is that you have a right to a jury. It is clear under Illinois law that the jury needs to be sworn in, and here the jury was sworn in. I don't think that there's any...
But they weren't sworn in as a juror.
Well, they were still sworn in as a jury. The contents of the oath that they were read was appropriate to their role as a veneer person. You promise to answer questions truthfully and so on. But they were still sworn in as a juror. And it is worth noting that both court counsel and the court itself, through statements both before and after trial, as well as in the jury instructions, repeatedly reminded the jury of their solemn duty to decide the case in an impartial manner based on the evidence in front of them. So they were clearly sworn in as jurors, but even if they were merely impaneled as jurors, as a matter of Sixth Amendment law, they would be a jury and could hear a trial. In terms of jurisdiction or the authority to hear a case, this court's been clear that in Illinois, that derives from the Illinois Constitution. So cases from other states that discuss the role of the jury oath as providing authority or jurisdiction in those states are inapposite in Illinois.
Are you contending, or do you contend that if this defendant were acquitted, the state could not try even though the jury wasn't given the oath, the proper oath, jeopardy would attach and the defendant could not be retried?
Yes, Your Honor. I want to make sure I'm clear on the negatives in the question here.
So
But
that's your position? then?
this defendant could not have been retried had he been acquitted.
When did jeopardy attach then?
Well, so the state is not in any way challenging, and holding that an error in the jury oath is subject to forfeiture in no way undermines this court's black letter rule that jeopardy attaches when the jury is impaneled and sworn. Everyone in the courtroom here knew exactly when trial had begun, when the moment at which defendant could have waived his right to a jury had passed, the moment at which the jury that had been selected was finalized. So the state's not challenging that black line rule in any way. It's actually defendant's position that muddies the water by suggesting that there might be a situation like this one where everyone understands the jury to have been impaneled and sworn, and yet jeopardy somehow might not have attached based on the contents of the oath that was administered. Even in a situation where the jury wasn't sworn at all, it's equally clear to draw a black line rule where the jury is impaneled to say this is where the trial's begun, but the court doesn't even have to get into that at all. I mean, the people are not challenging in any way, shape, or form the black line rule that jeopardy attached when the jury was impaneled and sworn, and everyone in the courtroom understood that moment at which this jury had been impaneled and sworn.
What I'm troubled with is when you indicate that sworn is a very broad concept. I mean, during a trial, a jury trial, there are different oaths that are given. There's the oath given to the voir dire when you're selecting the jury. There's the oath given to a witness. They swear to tell the truth and so forth. Then there's the oath given to the jury to try the case properly. The oath to try the case properly wasn't given in this case. A oath was given, one of possible 3 or more, right?
Correct, Your Honor. And
So no matter what the oath is, as long as they're sworn to do something, that fulfills the requirement.
Your Honor, under Illinois law, yes, but the court doesn't have to answer the question of whether giving an oath that doesn't get at what I don't think anyone disputes are the purposes of the jury oath is an error, because this was forfeited. So the question is this second prong plain error? And in a case like this one, where defendant received the benefit of the voir dire oath, of peremptory challenges, of the Zier principle inquiry, jury instructions, comments from the court reminding the jury of their role and how to decide the case fair and impartially based on the evidence in front of them.
But
that an error in the
that
oath.
oath wasn't given to them.
I'm correct. Well, so right, no oath that directed them as to their role as a jury was given to them, but to the extent that that is error under either Illinois law or the Sixth Amendment, it doesn't mean that it was an error that undermines the fundamental fairness of the trial or the integrity of the judicial process. Just like while an error in administering, 431B inquiry about the Zier principles clearly implicates the Sixth Amendment right to a fair and impartial jury, an error in doing so is not second-pronged plain error. Similarly with, depriving a defendant of or erroneously denying a peremptory challenge implicates the right to a fair and impartial adjudicator, but it's not second-pronged plain error. Administering the voir dire oath, this court has repeatedly recognized that while errors in any of these protections implicate the right to a fair and impartial jury, because of this panoply of protections of that right, an error in any one of those protections is not second-pronged plain error.
But none of those examples that you give would have been known to the founding fathers as a Sixth Amendment violation that would deprive someone of that right, correct?
Well,
Here we have, for instance, the dissent in Kane that goes through a great deal of history on the Sixth Amendment, what the founding fathers would have realized an oath to be and what a jury to be. None of the things, 431, all those other things really wouldn't have been known to the founding fathers.
I would disagree with that assessment, Your Honor, in a couple of ways. One, I don't think that the historical record is so clear that a jury was that it was codifying a sworn jury, but more importantly, certainly the principles, the zero principles and 431B are ideas that are fundamental to the Sixth Amendment right to a fair and impartial jury. The right, that the defendant has to be proven guilty beyond a reasonable doubt, that they don't have
Certainly the rights are, but admonishing them by rule, it would not have been known. I don't think the founding fathers would have said, you must admonish each juror as to these 4 principles. That would have been unknown to them. The rights would have been known to them, but the obligation to admonish would not have been. Here, the obligation of a juror to take an oath before actually sitting in judgment of another citizen very well would have been known to the founding fathers.
Even accepting that distinction as true, it doesn't mean that an error in administering that oath undermines the fundamental fairness of the trial or the integrity of the judicial process.
It seems to me you're suggesting then that as long as you give all these admonitions and jury instructions, when you're selecting the jury, you do all that correctly. And so then the juror is picked and no oath is given. It seems that you would say that, look, they had all this other stuff. They were told all these other things. So jeopardy attached and the conviction is proper, right?
Yes, we would agree that jeopardy attached and the conviction was proper. Now,
So
ordinarily,
given no oath at all. They're not standing up as 12 or 6.
there's no question that that would be error under Illinois law, if not the Sixth Amendment as well. But it's important to keep in mind here that we are talking about an unpreserved error. Had defendant objected, just as if they had objected in the hypothetical that you're presenting, it's an easily cured error. And we are not suggesting that defense counsel in this case was engaging in some kind of gamesmanship, but courts have recognized the valuable role that principles of forfeiture play in preserving judicial economy, judicial resources, and the integrity of the judicial process by making sure that curable errors are cured when they occur, when there's an opportunity to cure them. It helps preserve confidence that judicial proceedings are conducted without error. It helps preserve confidence in the finality of judicial proceedings, and courts have recognized that it does provide an incentive to parties to make courts aware of these curable errors when they can be easily cured. Had defendant objected when the oath was administered, it would have been very easy for the court to say, to its clerk, you read the wrong oath, can we do that again? Defendant didn't object here, so it's a forfeited error. And this court has held that, only errors that deny the defendant of the right to counsel or deny the defendant of an impartial adjudicator are not subject to forfeiture, our second prong, plain error. And that's not the case with an error in the jury oath. In a case like this one where we do have all of these other protections. The record doesn't show that he was denied his right to an impartial adjudicator. In fact, with all of these other protections in place, the record shows plainly that he received his right to trial before an impartial adjudicator, that it was protected by all these other protections.
That's part of the purpose of that oath, is to make
Absolutely, it's part of the purpose of the oath, just as it's part of the purpose of the voir dire oath and peremptory challenges and the zero principles and numerous other protections that certainly errors can occur. But where they are not preserved, where they're forfeited, they are not pronged to plain errors.
But as Justice Burke has suggested, those are different categories than the one we're talking about, the oath we're talking about.
I don't think they're different categories for purposes of determining whether they are subject to forfeiture.
No, I'm talking about different because of forfeiture and whether they're subject to forfeiture if it was an impartial jury. Because an impartial jury is not subject to forfeiture.
Absolutely, Your Honor, but I don't think the record here shows that defendant was in any way denied his right to an impartial jury. There was an error in one of the protections from the panoply that ensures that right. So in sum, Your Honors, in a situation like this, where defendant forfeited his claim of an error in the jury oath, and the record does not demonstrate that he was denied that right to an impartial adjudicator, the claim can only be reviewed if the evidence is closely balanced, and since defendant does not argue that the evidence is closely balanced here, the claim is not subject to review. Unless the court has any further questions, people would ask that this court affirm the judgment of the appellate court. Thank you, Your Honors.
Thank you, Mr. Fisher. Mr. Castaneda?
Thank you, Your Honors. Just a few brief points on rebuttals. I think Your Honors' concerns were correct. There was no legal jury formed here, as they were never sworn in. One of the cases which found structural error, the Pennsylvania Supreme Court in Commonwealth versus Robinson, found that when the jury is not sworn in, the defendant or the accused is simply a spectator at their trial because we have no trial. While counsel cannot find the contents of an oath within Illinois law, the state's brief on pages 22 and 23, they cite to Sir William Blackstone's commentaries, which was published in 1780, and that tells us the contents of the oath. At common law, the oath required that the jury be sworn in to render a true verdict according to the evidence. Ramos tells us we need to look to the common law to give meaning to the Sixth Amendment. So that is what forms a legal jury here under the Sixth Amendment, the swearing in of the jury with the trial oath. There was a lot of mention of 431B. I like to point out that 431B was not complied with here. The appellate court found there was error, and that is not required under the Sixth Amendment. It is the jury, the trial oath, that is required under the Sixth Amendment. And that is the only time when jeopardy attaches. Counsel also alluded that it is simply enough to just impanel the jury, but it is not. The jury has to be impaneled and sworn in order for jeopardy to attach. And specifically here in Illinois, again, to consider that is the point when an accused no longer has an absolute right to waive their jury and elect to proceed with a bench trial. And to suggest that jeopardy may attach under the voir dire oath flips the entire rule on its head. If they're given the voir dire oath and then selected, what about alternate jurors? What about when is it that the jury is informed? When does the trial commence? That injects confusion into the law. We have a nice bright line rule that's been working, and that is that jeopardy attaches when the jury is impaneled and sworn. This is such a basic, a fundamental right that two of the Supreme Courts, the Pennsylvania Supreme Court in Commonwealth versus Robinson, and the West Virginia Supreme Court in State versus Moore, both those courts said that further discussion is not needed. Further authority does not need to be cited here because it's such a basic function to the trial itself that it is a violation of an accused Sixth Amendment right. And I would like to point out that there is no case, no attorney who has ever argued before a court that we should do away with the trial oath altogether, because we can't. We don't have a trial without that oath. That argument has never been made, and it can't be made because it's required under the Sixth Amendment. And it is such a basic and fundamental right that, again, it's structural error and requires automatic reversal, because we need to remedy that right in order to preserve the integrity of the judicial process itself, because we don't have a trial without the jury being sworn. We don't have the legal formation of the jury. And for all these reasons, Your Honors have no further questions. Ms. Omega Moon asks that this court find that the failure to swear in the jury with the trial oath violates the Sixth Amendment right of an accused, is structural error, and requires automatic reversal. Thank you, Your Honors.
Again, it was again, I was thinking about the case before. You're suggesting when no one objected here, the trial court has sua sponte obligation to correct what had occurred when no one brought it to her attention. Is that correct?
Yeah, it is. It's everyone's duty to ensure that the jury is sworn in. The trial judge admitted that it was her duty to swear in the jury. Absolutely. So it is the trial judge's.
So at every turn, the trial court has a duty to be, without any objection, without anyone bringing any issue to their attention, the trial court has an obligation at all times to be listening to any possible error that might be entering into the record?
To this specific error, yes. So does the defense attorney, so does the state, because they have to ensure that they get a legal conviction. And again, I think that points to the structural nature of this error. It's in everyone's interest to ensure that that jury is sworn in. Otherwise, we don't have a legal determination of innocence or guilt. Yes, Your Honor, it's the trial court's duty, it is the defense attorney's duty, and it is the state's duty to ensure that that jury is sworn.
And so the defense breached its duty as well?
If he breached his duty, everyone in the courtroom breached their duty, yes. And the person who was left here to suffer was my client, Ms. Omega Moon, who was never provided her right to a Sixth Amendment jury trial. And I think I want the court to focus on that. And I would point to the dissent in Arellano. There, the dissent criticized the majority for punishing the defendant, the accused, for trial counsel's tactical harboring of the error, instead of focusing on the issue of ensuring the Sixth Amendment right to a jury trial to an accused. And I think that's the focus here, is that Ms. Moon did not receive her right to a jury trial. Your Honors, thank you for your time. There are no other questions. Thank you.
Thank you, Mr. Castaneda. Case number 125959, People of the State of Illinois versus Omega Moon, known as Agenda Number 3, will be taken under advisement. Thank you, Mr. Castaneda, and thank you, Mr. Fisher, for your arguments